My name is Natalie Mera. I'm the Executive Director of the Ontario Health Coalition. Thank you very much for being here today. This is a media conference about Bill 218. It's the legislation that makes it harder to sue long-term care and retirement home companies, among others, for negligence and unreasonable or not good faith efforts to protect against harms from COVID-19 during the pandemic. And I'm going to start with Gary Will. Gary Will is a managing partner of Will Davidson Law Firm. Welcome, Gary.
Well, thank you, Natalie, and I want to thank you and the Ontario Health Coalition for arranging this press conference and for inviting me to speak. It's fitting that we're here on Remembrance Day, a day to honor our veterans for their sacrifices. And we're talking about another group of our elderly population where over 2,000 have died this year, and many tens of thousands have been adversely affected in their long-term care and retirement homes. Long-term care homes are meant to provide care for the most vulnerable members of our population. Many of these individuals are disabled mentally and physically, and they're entirely dependent on their caregivers for their daily needs. They can't speak for themselves in many cases, and in many cases, their families don't know what's occurring with them and how they are being treated. And the impact of the pandemic has been horrific on this community. Over 65% of the deaths in Ontario around 2000 have occurred in long-term care homes. Many of these deaths were preventable. We have over 600 long-term care homes in Ontario, and the majority of these homes have zero infections and zero deaths. At the other end of the spectrum, there is a small minority of homes that have accounted for the vast majority of the infections and deaths. And those bad actors should not be shielded and protected from liability, which is exactly what Bill 218 does. We represent over 2,000 residents and their families in 9 long-term care homes. And of those, 711 were infected with COVID and 261 unfortunately died. So what do these families want? Well, first, they want to know what happened to their family members. And they want there to be accountability and responsibility. And finally, they want to ensure that this never occurs to any other family ever again. And what does this legislation do? Well, there will be no responsibility and no accountability for negligent conduct. Long-term care homes can act unreasonably, provided that they make an honest effort. And a long-term care home that earns over $1 billion in revenue can act negligently, and there will be zero consequences. Bill 218 bars claims for negligence, and all existing actions are deemed dismissed without cost. And for those individuals who are unable to prove gross negligence, this means there's no accountability, no responsibility, no answers, and no compensation. And what does this do for future residents and their families and the care that they can expect in the coming months? We're into a second wave, and we may have further waves in 2021. The care of those residents will not be better. It will likely be worse. Extended care, which has earned over $1 billion in revenues in each of the last 3 years, can cut back the care that they provide to increase their profits, and there will be zero consequences for their negligent actions. And they can do so secure in the knowledge that Bill 218 shields them. The decisions that they make, which will affect the quality of care in our homes, can be unreasonable, according to the legislation, and our elderly population will bear the brunt of those decisions. There will be more infections, not less, more deaths, not less. No one in Ontario wants that. And if we want to improve the quality of care in our long-term care homes, there should be an exemption from Bill 218 and should not apply to residents of long-term care facilities. So why is the Ontario government resisting this? The official opposition made a number of amendments to the legislation to provide such an exemption. Well, the Conservative government is unfortunately more interested in their friends in the long-term care industry and the insurance industry than they are in the than they care about elderly, vulnerable residents in the long-term care homes. And why is that the case? Well, there's an extremely strong connection between the Ontario Conservative Party and the long-term care lobby. The last three Conservative premiers have strong ties to the long-term care industry. Bill Davis is the chair of the board of directors of Revera. Mike Harris, former premier, is the current chair of Chartwell. Ernie Eves is connected to the board of Central Park Lodges. And many of the senior Tory strategists and power brokers are now lobbyists in the long-term care industry. Doug Ford's former War Room director, Melissa Lanceman, is the current lobbyist for Extendicare. Lauren McDonald, former director of marketing, is the lobbyist for Revera. Ford's former senior staffer, Andrew Brander, is the registered lobbyist for the Ontario Long-Term Care Association. And the list goes on and on and on.
Okay.
So the long-term care lobby has funneled over $600,000 to political parties in Ontario since 2007. So it isn't fair what they're doing, and it's extremely unjust, and it's shameful conduct on the part of the government. And I want to turn it over to Greg McVie, who is one of the family members who has been thrown under the bus by the Conservative government, and he's the representative plaintiff in the Seven Oaks class action. So go ahead, Greg.
Thank you, Gary. Good day. I'm the son of Joseph and Joan McVeigh, who were residents at Seven Oaks Long-Term Care in Scarborough. Both of my parents are deceased. They died 9 days apart from COVID-19. My parents both served their communities with honor. My father was a soldier in the British Army and a Toronto police detective. My mother was a child care worker with the Peel Lunch and After School program. I repeatedly asked Seven Oaks and various levels of government to implement measures that would protect my parents and the other residents. Those requests were repudiated and only to be implemented after their deaths. Our family lost them both within 9 days, both deaths preventable. The hurt is immeasurable. Taking away rights from their estate only amplifies this pain. Throughout this pandemic, hardworking people like my parents, due to their age and disability, were treated like second-class citizens. They were an afterthought, expendable, not as important to keep alive. Now, through political expediency, if it wasn't bad enough that their rights were diminished while alive, the province wants to remove rights away from their estates. Bill 218 prevents families like ours from finding some form of justice and ultimately closure on their preventable deaths. Doug Ford ran on a platform of For the People. My question for Doug is, what people? Certainly not hardworking people like my parents and the veterans and other hardworking people that live and have died in our long-term care facilities. Doug wants to erase them and this tragedy from our collective memories. In closing, I ask you to picture this. A week before the pandemic was declared, my mother was dancing to live music and my father was reading the newspaper and watching action movies. Thank you.
Thank you, Greg.
And I now want to pass you over to Sylvia Lyon, who lost her mother at Orchard Villa and is the representative plaintiff for that class action.
Hi there. On April 23rd, my mother died of COVID-19 at Orchard Villa. In 1974, she survived brain cancer, but her treatments had long-term effect. She became completely deaf, partially blind, and wheelchair bound. She lost much control of her hands and her speech became incoherent, and she had difficulty swallowing. Through sheer will and determination, she struggled on, vowing not to let these challenges get her down. At Orchard Villa, she had a private room. She was immobile in her wheelchair and she was being fed in her room. So the only way she could have gotten the virus was because it was brought to her on contaminated items or through staff contact. It's not right that a person who coped so valiantly for so many years was betrayed by the very place that should have kept her safe. As her daughter, I also feel betrayed by governments of all stripes who seemed unwilling to prosecute certain care home owners and operators who had a long history of non-compliance with regulations and who created a perfect scenario for COVID-19 to set in. The tabling of Bill 218 is like being punched in the stomach when you're already down. It's going to make it even more difficult for families to hold these care homes to account. I truly hope that at this 11th hour, our government will change its mind and exclude care homes from Bill 218 so that at least we can seek justice for our loved ones. Thank you.
Thank you very much, Sylvia. I'm going to turn it over to Graham Webb. Graham is the executive director and he's a lawyer at the Advocacy Center for the Elderly.
Well, on behalf of the Advocacy Center for the Elderly, first, I'd like to express our heartfelt condolences to the Lyon and McVeigh families. And these are homes that we're quite familiar with. We've been in them many times. We've had clients there, and we can imagine what things look like because we've been there so many times. And on a personal level, to Sylvia McVeigh describing your mother's death, I can personally sympathize as well because my 98-year-old mother is in a personal care home in Winnipeg, Manitoba, where there are 11 active COVID cases on the floor below her and 2 active COVID cases on the floor above her. And she too is in her room, isolated, merely waiting for the virus to come if it comes to her, if it is brought to her like it was brought to your mother. And it pains me greatly to hear your mother's story. On behalf of the Advocacy Center for the Elderly, I'd like to sort of leave politics aside and speak purely to the public policy considerations of Bill 218. As you've heard, Bill 218, among other things, introduces a heightened standard of gross negligence for COVID-related claims against long-term care homes and retirement homes and other businesses. It's our position that long-term care homes and retirement homes should be cut out of Bill 218. It should not apply to the standard of gross negligence should not apply to long-term care homes and retirement homes for these reasons. Firstly, the ordinary standard of negligence is more than enough to protect the many non-negligent long-term care and retirement homes from civil liability for COVID-related claims. You've heard from Gary Will that the majority of homes did not have cases and did not have deaths. These homes may have had very effective infection control and prevention procedures that protected their residents. They have no civil liability and they don't need the protection of Bill 218. Secondly, Bill 218 would protect long-term care and retirement operators whose negligent acts or omissions led to otherwise actionable COVID-related claims. Bill 218 protects negligent long-term care and retirement operators whose degree of negligence does not rise to the level of gross negligence. Thirdly, the legal interpretation of gross negligence in the long-term care home and retirement home context is very vague and uncertain. There are no case precedents to rely on. It's not yet known how courts will interpret the standard of gross negligence. And this gives rise to additional litigation risks and uncertainty for plaintiffs seeking civil redress against negligent and/or gross negligent long-term care and retirement home operators. This law protects the bad actors. Fourthly, there are already significant power imbalances between long-term care homes and their residents. These power imbalances create barriers to access to justice for vulnerable long-term care and retirement home residents that will only be exacerbated by invoking the good faith defense and a standard of gross negligence for civil liability. And finally, fifthly, long-term care homes and retirement homes are in the business of providing high quality care to their residents. Good public policy demands that they should be held accountable in damages when they cause harm or injury to their residents through their acts or omissions that amount to either negligence or gross negligence. And I'd like to speak again to some of these points, simply that there are many other Ontario laws, or at least a few other Ontario laws, that provide a standard of gross negligence for civil liabilities. And some of these laws are laws that protect rescuers from providing emergency care in emergency situations where they are not being compensated and they are not providing emergency intervention in expectation of any reward. You know, there's the Good Samaritan Act, where a person or a regulated health practitioner finds someone in a situation of distress, an emergency, and they provide emergency treatment. They're not held liable, provided they're not expecting compensation or reward. There is Sabrina's Law, which relates to school board employees administering treatment for anaphylactic reactions. There's the Heart Defibrillator Civil Liability Act, the Chase McEachern Act, where someone applies a defibrillator in an emergency situation. They too are not responsible for damages, except in the case of gross negligence. And even Bill 218, where it applies to someone like a retailer who's selling clothing or a minor hockey association, you know, the retailer is not in the business of providing care. Providing care is what long-term care homes and retirement homes are hired to do. That is the very essence of their relationship with their residents. And in the view of the Advocacy Center for the Elderly, long-term care homes and retirement homes should be expected to provide high-quality care without negligence in the very caregiving duties, including things like infection prevention and control. And where they act negligently, good public policy demands that they should be held accountable and liable in damages. Thank you.
Thank you very much, Graham. I'm just going to conclude for us where the bill is at. So Bill 218 passed second reading and went to hearings last week. It was moved very quickly through the legislature. The hearings were perfunctory. 58 people applied for standing. Only 15 spaces were made for standing. So only 15 people got to present, even though the bill is retroactive. So even if it were to pass a month from now or a month and a half from now, it would still be retroactive. That's how it's written. So there is no justification for moving it through with incredible haste. But a number of the families were not able to present before the standing committee. Dozens of people who applied for standing were not granted standing and couldn't present in the hearings. We did ask for an extra day, 1 day of hearings in order to accommodate the families that wanted to present and government MPPs who control, it's a majority government. So the Ford government MPPs control the majority of the committee and they did not allow that to happen, although we had the support of both the Liberals and the NDP on that. We asked for an exclusion, a carve out of long-term care and retirement homes from the bill. And that was brought forward in motions. Yesterday, the bill went to clause by clause reading in the committee and the Conservative MPPs voted down all of those amendments. So they did not amend the bill and they did not carve out long-term care and retirement homes from the bill. The hearings, to our distress and unusually, were not broadcast, and the media could not actually watch the hearings, and nor could the families or the public. At every step through the last 6 months, we have watched injustice upon injustice heaped on the families of the people who have suffered so egregiously in long-term care. In the first wave, we saw almost 2,000 people die, just almost all of them within 2.5 months. And in this wave, we're now at more than 215 people that have died just in the last 2 months. And the numbers just in the last week in long-term care homes have exploded. And in those homes where you see COVID-19 marching through the home, where, you know, October 18th, there was 1 person infected, October 26th, 36 people infected. By the end of October, 120 people infected, and so on. And we're seeing that now in home after home after home. When you drill down, what you find is that the workers don't have access, even now, to PPE that is appropriate. They're being told that N95 masks are not necessary. The homes, of course, have to pay for those masks. They're not changing their PPE between residents. Residents are not isolated quickly enough. Testing is not being done quickly enough. In many of the homes, there is no care, very little care. Staffing crumbles as soon as the infections start to spread. And like in the first wave, neither could the families get in to provide the care, nor was the care being provided by the home, nor did anyone move them out to hospitals or field hospitals or anywhere where there would be care available for them. Families watched this happen with utter horror, and they're watching it happen again. And I'm sorry if I'm a little emotional, but there's a time when things are just so wrong that you can no longer accept it happening. This bill, I've done this for 20 years. We have watched egregious things happen. We've seen terrible behavior by long-term care companies. I have never, in the 20 years that I've done this, seen a situation like this where so many people are left, they're dying of dehydration and starvation. They're dying alone. They're dying in squalid conditions. They're dying without care, without access to their families. This is beyond anything that anyone in our society would consider moral. Now, at this point, to allow the home operators to be indemnified against for liability for their negligence and their gross incompetence and what can only be described as their disregard for the lives of their elderly residents is beyond any moral code that we have as a society. It violates every set of ethics that we have as a society. These people had meaning, they're precious. And we know from the history of working for improvements in long-term care that the industry lobbies for profits at the expense of the public interest regularly. But other jurisdictions have actually refused to follow the industry lobby for tort reform, what they call tort reform, or legislative reform that indemnifies them against liability. In Kentucky recently, for example, Extendicare tried to get tort reform to indemnify it against liability for in the face of a slew of negligence lawsuits. The state legislature refused to do it. Extendicare sold its holdings and left Kentucky. That was after it had left Florida and Texas for the same reason, also states that refused their lobbies for tort reform. In the United States, in Massachusetts, the state attorney general is actually pursuing criminal charges against long-term care homes that have been grossly negligent and allowed or enabled the spread of COVID-19 in their homes. And the US Department of Justice is pursuing every avenue to hold the homes both criminally responsible for their behavior. The difference in Ontario could not be more stark. And because there is no reason not to carve out long-term care and retirement homes from this bill. If the bill was about protecting small sports teams and voluntary organizations, they can do it. They can carve out long-term care and retirement homes. And yet the government is not doing that. Instead, they're moving forward as quickly as they can to get this bill through. It's going, and so I think this underlines what we're concerned about, which is that this is in response to a lobby from the industry, which is majority for profit and against the public interest. They're going to third reading next week. So we have a few days, one weekend to mount a last-ditch efforts to call on MPPs to vote their conscience and to amend this legislation to carve out long-term care and retirement homes. And with that, I'm going to open it up to questions. Thank you very much.
Thank you, Natalie, and thank you to all the speakers. So for the Q&A portion, once again, please indicate you have a question in the chat, and then I will ask you to unmute yourself. The first question comes from Chris Glover of CBC. Chris, you can unmute yourself now.
Hi there, guys. Thanks so much for your passionate speeches there and for holding this press conference. We appreciate it. I just have a quick question, probably for one of the legal minds here, and that is around how Bill 218 compares to the ministerial order that was put in place in British Columbia. How does it compare to the protections that were introduced there?
Gary?
Yeah, so I'm not all that familiar with the BC legislation, but what I do know, the Ontario legislation goes far beyond what BC provides. In BC, at least there's a standard, an objective standard that is applied. Here in Ontario, you can be unreasonable and be protected. You can have unreasonable conduct which is protected, provided you have an honest belief. And my understanding of the BC legislation is that there are objective measures that will apply. And that's really the whole basis for our rule of law, is that if you're acting reasonably, you're protected. I mean, all you have to do is act reasonably in accordance with the standard of care in the industry, and you don't have to worry about lawsuits. When you act unreasonably and you act negligently, then you're responsible for the consequence of that negligence.
Graham, did you want to add anything to that?
No, I had nothing to add to that. Thank you.
Chris, did that answer it for you?
Yeah, it did. I mean, I think we're going to have to do a bit more digging on our side to find out what the differences might be between BC. So that's still a question that we can try to sort out. The other thing that I'm wondering if perhaps the government may come back and suggest that by omitting gross negligence from this bill, the sorts of bad behavior that have been outlined would not be protected via this bill. I wonder. What would any of you say to a government official that tried to make that argument?
Graham?
Well, I don't think we really know what gross negligence is in the long-term care home and retirement home setting. Whether a negligence amounts to gross negligence is a finding of fact that's based on the evidence. And in many other cases where there's been a legal history of judicial findings of what forms gross negligence, we have something to go by. For example, if you slip and fall on ice and sue the municipality, you have to show gross negligence, and courts have something to go by in terms of previous decided decisions. And so as a lawyer, if you're bringing a case forward based on gross negligence, it's difficult to advise your client really what does form gross negligence. And it's also difficult for the court to decide what differentiates negligence from gross negligence, except for the decided case law, the old decided case law, which says gross negligence is a very great negligence. And, this poses additional barriers to access to justice because individuals don't have the resources that a multi-million-dollar long-term care home business that it has a policy of liability insurance to defend it has. And so you're left with greater uncertainty about what a court may decide, a higher threshold, not knowing what the signposts are.
Gary, did you want to add anything to that? Negligence is already pretty high bar to meet, is it not, in Ontario?
Well, it's an unknown bar. So I think Graham's comment that there isn't an established body of case law around the concept of gross negligence. So gross negligence is going to be what the courts define it to be in the context of the long-term care industry. So there are no precedents. This is an issue that will go to the appellate courts and all the way up to the Supreme Court of Canada. So what that means is that people that are engaged in this litigation are in for a 10-year fight, because that's how long our justice system takes in these types of cases. So this is giving a powerful weapon to the insurance industry and the long-term care lobby to fight off these lawsuits, because they will use their monetary resources to fight off these cases, and we don't have an established jurisprudence to fall back on, and everything will be for their advantage, and they will use this weapon to fight off these lawsuits, and that's very distressing.
Okay.
And
Sorry.
I would like to add that this not only clogs up the court to the back end at the appeal stage, but it also clogs it up at the beginning and in the middle, because there may be motions to throw cases out on what's called a motion for summary judgment. And, this can affect the case at the very beginning, where the defendants can say, well, the case you pleaded doesn't amount to no gross negligence, and those issues may have to be heard. And in the middle, there will be many, many cases where there are both COVID-related claims and non-COVID related claims, and the COVID related claims would have a standard of gross negligence, and the non-COVID related claims would have a standard of ordinary negligence, and the judge or the jury, if the jury is the finder of fact, will have to differentiate between the two standards, negligence and gross negligence, depending on what the particular thing is in the same proceeding. And so all of this is not going to unclog the courts. It will clog the courts up even more in the beginning, the middle, and the end of the litigation.
Thank you.
And just finally, for me, I understand. Thank you so much to the two families who are speaking today. I can't even imagine how difficult it must be for you both to be here and to be speaking publicly about your loved ones like this. But I wonder, how would this bill, if it were to be enacted, I know that it's retroactive to the beginning of the pandemic, how might it impact the lawsuits? I know that there are several of them across the province. How would it impact that legal work that's already underway? Would all of them be thrown out? Is that the fear?
Gary, do you want to go ahead with that, or one of the family members?
Yeah. So, I mean, I want to reassure all of the family members that I represent that we're not giving up. We will fight this legislation. We will fight these cases through to the end. I've talked to hundreds of family members that since the beginning of this litigation, and I promised that I would deliver justice to them, and the fight will go on. If the bill passes, it'll be a more difficult fight, but the fight will still go on. And we will be able to persuade the government or the court that your cases are deserving of justice, and that will be the ultimate goal.
Thanks.
If I may echo what Gary had just said, is that we have spoken with many other plaintiffs' lawyers who have said their cases are going ahead as well. If their cases did not already allege gross negligence, then they are now in the process of amending their claims to allege gross negligence. Those amendments might be resisted by the insurers, in which case there'll be even more litigation over things like the amendment of pleadings, which is a waste of time and resources and will make litigation more lengthy and more expensive, and create greater burdens on the court that need to deal with very serious issues on other areas, such as criminal cases that are at risk of being thrown out for constitutional violations under the Jordan case.
Thanks, Graham. Okay, I think we have a bunch of questions, so we'll move on to the other questions. I just wanted to very quickly make a note. Chris, for the BC emergency order, I realize you asked the lawyers, but the order pertains to gross negligence. It does not, the Ontario Act makes it both easier to defend for the industry and harder to sue for the plaintiffs. The BC order is different than that. That's what Gary was trying to describe to you. So it doesn't include the part that is makes it easier to defend. And BC does not have the same proportion of for-profit long-term care homes as Ontario does, and nor did it have the same deaths and really, horror stories and egregious conditions that we saw in Ontario as well. So there are sort of operative conditions that are quite different as well. Sorry, we're not all going to weigh in on every question. We promised we wouldn't do that, and we won't. Sala, go ahead.
All right, the next question comes from Sue-Ann Levy of the Toronto Sun. Sue-Ann, you can unmute yourself now.
Did already. I jumped the gun. I want to thank everybody. I've talked to pretty well all of you. And Graham, I want you to know that my dad has COVID. He's in a facility, 91 years old. So it's a very scary time.
I'm very sorry to hear that, Sue-Ann.
Yeah, he's holding his own. But in any event, Chris already asked one of my questions about the lawsuits being thrown out. But I wanted to ask, does this set a precedent? I know these are COVID-related cases, but does this set a precedent in terms of the long-term care industry and people actually mounting cases with respect to negligence involving all kinds of other things? I know you separated out negligence and gross negligence, but could the pendulum swing further in the direction of gross negligence if this passes?
Okay, so I'm going to ask Gary and Graham to answer that. And I forgot, I'm sorry, I wanted to introduce Jane Meadis, whom many of you know, who's an institutional advocate and lawyer at the Advocacy Center for the Elderly, and also here to answer questions. Gary, do you want to start, and then Graham?
Yes.
Quickly on that.
Thank you for that question, Sue-Ann. And the precedential nature is also very concerning, because governments, with a stroke of a pen, wiping out lawsuits is almost unprecedented anywhere in the world. And 2 years ago, the Ontario government, again, Doug Ford, introduced the Crown Liability Act, where, with the stroke of a pen, he wiped out existing actions against the Ontario government. And there were many thousands of victims. Their cases, which had been litigated for 5-6 years at the time, were eliminated. And now there's this further piece of legislation, which again applies to existing lawsuits. Again, very unprecedented. So the dangerous aspect of this is, well, what's going to happen next year and the year after? A government that is so used to wiping out the rule of law can basically apply this to any lawsuits that they think there are too many of. So they can say next year, well, gross negligence, you have to be grossly negligent in the medical malpractice context. We're going to wipe out lawsuits unless there's gross negligence. Or how about car accidents? You don't have any remedies unless there's gross negligence. Governments can do this. And this government has now done this twice. And it's so easy for them to do it in the future. And that's extremely dangerous and concerning.
Okay, so it's a political precedent. Graham?
One of the underlying purposes of law is to provide leadership to the legal community and to the community at large on what are acceptable social standards. And what's really disturbing about this is that it sets an expectation that older adults living in long-term care homes don't matter. That's the message it sends. And that's really an unacceptable message. I think there is a widespread belief that this legislation is motivated by the inability of long-term care homes to obtain liability insurance for COVID-related claims. And there are many public policy options that could correct that problem. We at the Advocacy Center for the Elderly are so disappointed that the public policy option chosen is to resolve the liability insurance problem on the backs of long-term care home residents who have been killed or injured through the negligent actions of long-term care home operators. That's an unacceptable solution. The correct public policy answer would be to support and enhance the rights of long-term care home residents to live in a safe and clean environment, free from COVID-related infections, and to expect operators to provide high quality care without negligence, and to solve the insurance problem in a different way. This is the wrong public policy response.
If it is an
Natalie,
insurance thing. Yes, Jane?
I'd just like to make one comment in that, the long-term care industry has really gotten away sort of scot-free in the past. There has been little to no litigation against long-term care homes historically, and it's only been in the last year or so where we've seen any litigation against homes. So it's not like they're, reeling from prior litigation. That's not the case. In fact, litigation has been very rare because of the cost, because of the uncertainty, because of the devaluing of the elderly resident in long-term care. And so this is just a continuation of that, saying, you haven't had any problems in the past, and we're just going to continue that.
Thanks. Thank you.
I just have one follow-up. So looking down the road, if this bill passes, are we going to see more of the kinds of things that happened at Orchard Villa? And I'm not talking about COVID. I'm talking about just the sheer negligence. What incentive do these homes now have if the bill passes to clean up their act?
The answer to the question, will we see more of the same? The answer is yes. This is the get out of jail free card. This is the government action that sets the precedent for, if you act negligently, don't worry, we'll take care of you.
If I can
Well,
answer this, oh, sorry. Okay. Go
Yeah,
ahead.
I would argue it's likely going to get worse because, all of this happened when negligence was the standard. Back in March and April and May, you knew if you acted negligently, you might be held to account in a court of law. Now, there is no accountability for negligent conduct, and you can act unreasonably and be shielded. So what is going to happen? It's more likely going to be more infections, more deaths, and worse care to these residents. We should be trying to enhance the level of care, not decrease the level of care.
If I might also just, Sue-Ann, I think you know this, but just to reiterate, the homes have already escaped all of the levels of accountability that should have existed all the way along. There have been no fines. There have been no licenses pulled. Every level of protection that families should have had leading into this has failed. The government has not upheld them. They have not applied them. They have not enforced them. And to now, when it's too late for these people, they've died, they're gone. The only remaining access to justice and hopefully a little bit of closure for the families is to seek litigation. It's not normal for people to do. We don't have a particularly litigious society, and it doesn't happen. It just doesn't happen. And now that avenue that hill to climb has been made much more steep. And I think the other issue is that jurisdictions, just because some jurisdictions have given into the lobby of the long-term care home industry to give them these exclusions, does not mean that we should. And the more jurisdictions that do it, the more that will do it. There is a precedent there as well. And so I just wanted to emphasize there are other jurisdictions that have refused to do this. They've said, listen, if you're negligent, let the courts decide. That's justice. And that is not happening here. Sorry. Other questions? Oh, so Sue-Ann, did you get everything you needed there?
Perfect.
Okay. Salah?
Yeah. So the next question is a question I'll read out. This is from Roseanne Nicole of Radio Canada. Mr. Will, could you precise how many clients you're representing at the moment and how many lawsuits/class action lawsuits you're working on at this time?
So we currently have 9 class action lawsuits. We've been contacted by many individuals even beyond those 9 homes. We haven't pursued every single claim. We make an evaluation of each case as it comes in and decide whether to pursue it or not. So within those 9 homes, there's about 2,000 families, 2,000 residents that are impacted. And if the case certifies as a class action, we will represent all of those residents and their family members unless they opt out. So currently, if the cases get certified, it will be around 2,000 residents and their families.
Thank you. And just in case what you're trying to measure is how many class actions there are, we've been tracking, at this point, we've found about 26 in long-term, they're in long-term care against long-term care home operators and the Ontario government. And we've not found any other lawsuits against any other industry or business in Ontario related to COVID-19. So, you know, this legislation, we believe, really is about long-term care operators. Go ahead, Sal.
Absolutely. The legislation is directed to eliminating long-term care home lawsuits. The Conservative talking point on this is, well, we have to protect hockey coaches, you know, from COVID-related litigation. There isn't a single lawsuit of a hockey coach. There are no lawsuits against mom and pop small businesses. The lawsuits are for the long-term care industry, and those are the lawsuits that are going to be eliminated. And this is just a talking point that we need to protect small business to get the economy reopened. There aren't any lawsuits involving those businesses.
Thank you. Sala?
If anyone else has any questions, you can indicate that in the chat. Those are all the questions I've seen so far.
Okay, thank you very, very much for joining us. We really appreciate you taking the time and joining us today, and for all of the work that you've done on these issues. Thank you. Heartfelt, thank you. Bye, everyone.
Okay.